Please.
Thank you very much. Good morning, everybody, and thanks for the invitation to the Defender of Rights to make this presentation. I think it's a very timely and very useful seminar again, because we're all looking for some benchmarking in order to improve our own systems in the perspective of the transposal of the directive. And just maybe a clarification, I'm not the highest expert in the field at the Défenseur des Droits. It is more my colleague, Sylvie Ramondou, that really deals on the spot with the cases we receive on the issue. She feels more at ease to speak in French, so she will be definitely following the seminar and maybe participating to the debate after that, to the discussions, in order to maybe give some more information, more specific maybe information about the cases that we deal with. So I'm going to try to upload my presentation. Just a minute. Okay. I don't know. Okay. On part en train de partager l'écran. Okay. All right. Do you see my presentation? I have a problem to. Okay.
Yes. Could you put it please in full screen? But we
Yes.
can see it. Yes.
So we did that yesterday. Okay. Here we are.
Yes.
All right. Okay. And is it okay now?
It's excellent. Thank you.
Okay. So we are more. Have to start. Okay. So all right. In France, we had really a new system for the protection of whistleblowers that came out in 2016 with a new law named Law Sapin 2, out of the name of the minister that was in charge of this law, and that was willing to kind of improve the internal system, the national system, with more transparency and protection for the whistleblowers. The name of the law is on the transparency, the fight against corruption, and the modernization of economic life. Why did we have this law in France at that time, on 2016? Because we had some previous scandals that occurred in France. Ines mentioned before, during the morning, the mediator scandal that was supported. Well, I mean, the person in charge of the whistleblower, actually, in that case, was Irène Frachon, that made public the problem of this medicine and the fact that it caused, of course, the death of hundreds of people in France. The second scandal was the Cahusac case. It was a case of tax fraud and laundering, with the responsibility of the then Minister of Budget in France. So it was two main cases that occur in France that raised concern about the issue. And there was of course the need to spread a culture of reporting in France that didn't really exist and still is kind of trying to get born in France. It's not already the case, to speak the truth. Through the establishment of an effective procedure. This was really asked and demanded by the Conseil d'État, which is in France the highest administrative court that we have. The thing about Sapin Law 2 is that it has a limited scope, because we already had pre-existing sectoral laws for whistleblowers, for example, in the fight against corruption and conflict of interest, and also in the fields of health, safety, and environment. So the great ambitions of the law was to define a common base for the whistleblowers' protection, to try and harmonize the different whistleblowers' protection systems. As I said before, there are sectoral fields of protection, and we have a kind of inequality between the level of protection of whistleblowers depending on the field addressed. The idea also was to make further progress on transparency, of course, freedom of expression, of speech, and on the fight against corruption, and also to try and bring French legislation to the level of the best European standards in the field of protection. So it was the ambition of Sapin II. I think it is still our ambition today in the perspective of the transposal of the directive. What does this Sapin Law 2 law bring to the legal framework in France? First of all, there is a definition of whistleblower, and so it's an individual who discloses a report in a disinterested manner, which will make a difference with the director, the directive that doesn't give this precision in the definition, and that wants to make a disclosure about crime or an offense, a serious and manifest breach of in an international commitment duly ratified or approved by France, a unilateral act of international organization adopted on the basis of such commitment, on the law or regulations, or that want to denounce a serious threat or harm to general interest, which he or she has become personally aware of. So this is our definition at the time in France regarding whistleblower, who can be a whistleblower. Then, as other countries have, we have a graded reporting procedure in 3 phases, which is in our Article 8. There is a compulsory procedure. I mean, a whistleblower, in order to be protected, has to pass through these 3 levels of reporting. First, he has to go internal and to report to the hierarchy or to the alert referent. Then, after a, says the law, reasonable delay, if he hasn't any answer to that report, he can go to the external channel and report to an external authority, which is competent in the field of the alert. And should it be an administrative competent authority? It can be also the judge. And then, after 3 months, if he still or she still hasn't any response to the alert, then he or she can go public and report to the media. We can't skip any one of these states of the procedure, otherwise we can't be protected. The third thing of the law is that, it enhances the protection of the whistleblower against retaliation measures, dismissal, professional sanctions, etc. We have mentioned that before. There is, of course, also, as in the directive, an exemption from criminal responsibility if their reporting has led them to breach a protected secret. So these maybe are the main 3 things that the new law has brought to the national legal framework in France. In that framework, what is the role of the Defender of Rights, our institution? Maybe to start with, very rapidly, to present our institution, the Defender of Rights is an independent administrative authority that is mentioned, is inscribed in our constitution since 2008, but that was created back in 2011. It is the product of a merging of 4 pre-existing authorities that were the General Ombudsman in charge of the protection of freedoms and rights of users of public services. It was also the Defender of Children's Rights, the National Equality Body, the Non-Discrimination and Promotional Equality Body that was created back in 2005 after the 2000 directive, anti-discrimination directive of the EU. And also the 4th institution that was merged was the Police Complaints Commission. So because I think, and Zeta mentioned that before, I think because we had the practice of the adjustment of the burden of proof that we use in anti-discrimination cases, because of that expertise, we were given the mission to protect whistleblowers against retaliation. And actually, we have two missions regarding the whistleblowers. We have to orient them toward competent authorities, and then we have to protect them against retaliation measures. So the Parliament gave us this mission without really giving us as for other institutions the resources to do so. So today we really have only one person, to speak the truth, that is in charge of that is dedicated to the whistleblowers' protection. And then we have all the services working on retaliation measures, but we really had only a new person in order to take in charge this mission. Maybe some figures about the Defender of Rights for you to understand that the work that we do and the ways we conduct our missions. We have 226 agents in the institution, so dealing with all the other matters except one of the Defender of Rights. We receive more or less 100,000 complaints a year, and we also deal with more or less the same amount of complaints every year. We can issue decisions, but which are not compulsory. We are not a prosecutor's office, so and we are not a quasi-judicial institution, so we issue decisions, but they are not compulsory. We can make also recommendations. We made last year 694 recommendations. An important thing is that we have the power to go before the Parliament in order to give our analysis on bills that are in discussion and related to our fields of competence. Also, we can before the courts. We did that several times last year. We can go before all kinds of courts nationally, but also we go before the European Court of Human Rights and also the European Court of Justice at the level of the EU as amicus curiae, friend of the court, in order to deliver our analysis of the cases that we deal with. And we can refer also to the prosecutor. We did that in 4 cases last year. So for you to understand a little bit what we can do at the level of the Defender of Rights. Regarding whistleblowers cases in numbers, so as I mentioned before, we only have one really person dedicated to the issue. We don't receive too many files. Actually, we started with 16 files back in 2016, and now last year we had 84 cases related to whistleblowers. The referrals concern both private sector for 60% and the public sector 40%. We have a majority of protection requests against retaliations. So this is more or less, half of what we receive, 45%. Then we have orientation in 36% of our cases, and both of them in 19% of the cases. We have also a variety of topics that are addressed. 31% of referrals were related to economic field, fraud, embezzlement, conflict of interest, 50% related to issues of justice or security, and then 5% related to the field of public health. So again, as Zeta mentioned it before, there are different reasons, and I think it's always more or less the same reasons wherever you go that explain maybe a low level of referrals of reportings in the field of whistleblowers. We know that the system, and maybe in particular in France, has a deterrent effect for whistleblowers because of the numerous conditions to be met in order to benefit from the protection regime, which is not always very clear. And when people understand what is the regime, then they're not so willing to go for that. Also fearing, of course, measures of retaliation. But also the legal framework is still, and in France maybe more than in other countries, very, very complex because of the particular different systems coexisting and superimposed, and which make it difficult not only for the general public to understand the system, but also for lawyers in France. Also, I think that it's interesting to mention maybe the communication of the European Commission that also Zeta mentioned before from April 2018 regarding the Eurobarometer on corruption that was issued at that time, where it is mentioned that 49% of participants to the Eurobarometer don't know how to make a report nationally in order to denounce wrongdoings, and also 15% only do know the rules that exist in the national framework in order to do so. So this is still a big problem, and a lot of speakers during the seminar already talked about raising awareness and making some pedagogy in the field. But it's really important to not only to have a good system, but also to have it known by the general public and also the lawyers in the country. So how do we report to the Défenseur des droits? There's a specific procedure that exists actually in parallel of the other procedures that exist for all the other missions of the Defender of Rights. We had to put in place something different for whistleblowers protection. So the report is done in writing and under a double envelope. We have a sealing system for the computer data specific for whistleblower cases, and the processing is done by agents that are specifically dedicated to whistleblowers orientation and protection. So the one I mentioned before. We have, as I mentioned before, two main roles in terms of dealing with whistleblower cases. We have the orientation mission. So we can advise a whistleblower all over the procedure from the moment when he or she wants to make a report until the end of the procedure. So when we receive a report, we analyze it in order to see whether the facts reported may be related to the definition of the whistleblower provided in the law Sapin 2. Then we examine the conditions under which the report was launched. Again, the confidentiality, the 3 steps, procedures, etc. We then can indicate the claimant, the administrative authority that is competent in the field that is related to the report. And of course, we always, during all the different steps of the procedure, try to invite the claimant to respect the procedure, and in order for he, she to be really protected until the end of the procedure. The thing that we don't do, on the contrary of what Wildebert, for example, mentioned before, or on the contrary of the Lithuanian system, is that we do not decide on the content of the alert. We don't deal with the content of the alert. This is done by the other competent authorities. The second thing that we do, as I mentioned before, is to protect the person against retaliation measures. So we, when we receive the complaint, try to see whether the adverse actions alleged by the person, dismissal, professional sanctions, etc., are the result of his or her report, and which then will be, justify the protection of the person. So we have to really seek a connection between the moment when the person made the report and the retaliation measures. If there is a connection, then it is, as we mentioned it before, the reversal of the burden of the proof, and it is to the employer to show that they didn't made it because of the report. To do that, we have very important powers of investigation, as the Netherlands have as well. For private and public employers organization, we can go and ask for any document that will help us deal with the case, and we have powers in order to obtain them. Then we make the adjustment of the burden of the proof, as mentioned before, and we have powers of recommendation and powers to present observations before the court as well, in those cases. What are the shortcomings of the system? There are many. It is not as efficient as we would like. So, as mentioned before, we still have a big problem in terms of harmonization between the different systems that we have. We have different sectorial systems in the fields of intelligence, finance, and insurance, for example. Again, lack of harmonization between whistleblowers protection regimes that make the system, very non-transparent, not understandable, and not effective, because not equal between the different types of situations. We don't have any authority which is in charge of the follow-up of the alert, which is a problem because the defender of rights doesn't have such a power. When we orient a person towards the competent authority, we can ask the authority to give us some information about the way that they dealt with the case. And so this is a problem because we kind of lose track of what happens to the file, to the report of the whistleblower. And we don't have any authority like in other countries that is in charge of issuing a whistleblower status, that gives to the whistleblower the insurance that his or she is protected by the law, which is kind of a problem because it's only then comes when the judge decides that it is a whistleblower case, and but it comes at the end of the procedure. Of course, there is an uncertainty about the whistleblower status because it may change in the course of the procedure. If he or she doesn't respect the procedure, then he can or she can lose the status. So it's not a very stable also status, and it's maybe difficult to deal with that in that perspective. The actions that we took at the level of the defender of rights in order to address these shortcomings, we try, of course, to definitely have a voice in the public debate in order to raise all the problems that are that we have in our legal framework. We started that some years ago already after the Loi Sapin II back in 2017, then 18. We are regularly before the Parliament in order to give our advice when it comes to discussions regarding this law, but also now the transposal of the directive. We're in contact, of course, with the government in that perspective now. We tried and raised awareness of the public or private authorities to the whistleblower protection system. We organize, of course, trainings in order for them to understand what is the internal system they have to put in place. Loi Sapin II gave a framework and made it compulsory for a number of organizations to put in place internal procedures for the alert, which is not done actually at the moment. We only have, I think, as I remember, the last figures were 30% only of the organizations that have to put in place a system did so. So we still have well, improvements to do in that field. And also regarding the information of the general public, we made a guide, Orientation and Protection of Whistleblowers, back in 2017, which is also exists in English. So if you wish, so I could give the link to the organizers for you to be able to read it. And maybe also I could mention the conference that we organized 1 year ago, seems so long time ago, in Paris, where we could all meet actually at that time. And we issued the minutes of the conference last May, and we also have the minutes and summaries of the different speeches in French, in both French and English. So also I could also send the link to the organizers in order for you to be able to have that information. We don't have too many case law, a big list of case law in France regarding whistleblowers, but some of them have helped us to kind of improve the understanding of the law and the implementation of the law. So maybe as time rises, I will skip that part, but you will definitely have access to the presentation in order for you to get to know the different cases that we have dealt with or the judges have. And to, of course, conclude my presentation, I can give you some elements about what is going to change the national law in France if we transpose, and we have to transpose, and this is a very good thing, the directive in France, because there are several elements that have to be improved and the director is going to help us to do so. So we will have to review the definition of the alert, for example, by removing the conditions of the fact that the person has to be disinterested to the case, which doesn't help in some cases. I mean, it can be a case that affects the general population, but also affect the person as such. So this shouldn't be mentioned in the law. We foresee to expand the protection of those who have assisted to whistleblowers, as the directive says, including facilitators. This will be very useful for us and for many cases where we couldn't protect a number of persons that were involved in some cases. We have to facilitate, as Wilbur mentioned before, we are going to make the procedure more simple and remove the three-stepped graduated procedure in more or less 2 of them, as the director also requests. We have also, this is important for us, to more precisely define the second level of alert, and in terms of which are the relevant competent authorities in the different fields for the external alert, and what is the precise procedure to make the alert, because there, at the moment, if Sapin-II law gives specificities, details about the internal procedures to be put in place by the different organizations in the public and private sector, we don't have any precisions regarding how the competent authority have to be organized and how what would be the procedure in order to clarify things and make it more transparent for the general public. So we have to have that clarified as well. And these maybe are I think the main points that we are going to be working on, and that we are going to push in the national debate at the moment of the transposal. So this is it for maybe for the time being. Thank you very much, and we're available for your questions. Thank you very much.
Thank you very much, Nathalie. It sounded reasonable and meaningful, and I think it's important also to mention that the models of France and Latvia was created at almost the same time, and therefore we were able to learn a lot from you too, and it was a pleasure. Yes, the ombudsman model was also the original idea on our side, but it didn't receive political support at that time. We have also one question for you, and it's, do you think you would receive more reports in case if you had a secure online reporting platform? Could it be a solution?
Yes, but the issue of confidentiality for us is very important. And in order to respect in the best way possible the law, for the moment, we ask really to have it on paper form. Online, for the moment, we don't have the security and the insurance that the confidentiality can be protected. So for the moment, we are there, but maybe if we have more resources afterwards, we will ensure also the possibility to make an online reporting.
Okay, thank you very much for
certain national, of course, certain national institutions have done that in France, but for the moment we have done so.
Okay, thank you very much for useful points.